Hello. Today we're going to begin our study of evidence. I want to introduce you to the way to approach the whole law of evidence, the way to read the Barbary Outline, the way to organize the materials in your mind. As I said with torts and as I said with contracts, I don't want you just reading words and words and words, but I want you reading with a structure in mind so that things are fitting in their place. So let's see what is covered in the law of evidence and start with this. On the multi-state bar examination, the federal rules of evidence control. Depending on what state you're taking, some state law may be applicable. Some state law of evidence where it differs from federal law may be applicable in some of your essays. But basically, the federal rules of evidence are the controlling law on the bar examination. Whenever the federal rules don't control something, the Barbary Outline will explain the common law that's used in the federal courts. Okay? Now, three areas are particularly heavily tested, by which I don't mean they're the only things I want you to look at, but they cover most of what we need to look at. Relevance, rules pertaining to witnesses, and then a biggie, hearsay with its exceptions. Relevance is not just the basic rule of relevance, but related rules. Witnesses, lots of different rules about witnesses, impeachment being the biggest, but privileges and other things pertaining to witnesses being important. So three big areas and then some minor areas that we'll get to later. Relevance, witnesses, and hearsay. Now let's look at relevance, and you're going to be looking at the Barbary Table of Contents, which organizes it pretty well. We start with a definition of relevance generally. Then we have some special rules that exclude evidence even though it meets the definition of relevance. Yes, it's relevant, however, we exclude it for various reasons. And then we have a very complex set of rules about character evidence. Character evidence being relevant in the general sense of the definition of relevance, but having some prejudicial aspects so that we often, or as a general rule, exclude character evidence with all sorts of exceptions again. So we'll cover relevance in terms of the general rule, reasons for rejecting it, and then more definitely character evidence. When we come to witnesses, the two biggest things that we will be covering are impeachment of witnesses and privileges. You're going to have a number of questions on impeachment, and you're going to have at least 3 or 4 questions on privileges. And then our third big topic, pages 46 to 63 or so of Barbary's Outline, hearsay and its exceptions, tested very, very heavily on the exam. In addition to those 3 basic areas, other things that are regularly tested that don't particularly fit here are the best evidence rule. Really an original document rule. Often appears as a wrong answer, occasionally as a right answer, but it's important that you understand it. Authentication, which applies to a number of different things. You'll find that, by the way, best evidence rule, pages 19 to 22. Authentication, about page 14 of the Barbary Outline. We authenticate real things, real evidence. We authenticate documents, and we authenticate voices. So there are a number of different things where if we show that they are authentically what we purport them to be, then we can move on and maybe get them into evidence. So we need to learn about the rules of authentication. And then the relationship of the federal rules to state evidence law, also tested. When do the federal rules apply state law of evidence? 3 different times, basically, that we'll talk about somewhat later. In addition to that, questions about the relationship of the judge and jury in terms of evidentiary decision making. Okay? That's where we're starting as an overall picture of the law of evidence. These things, other than the big 3, are tested a little bit. But let's start with relevance. Nothing is more important, more fundamental than the concept of relevance in the law of evidence. And definition. I'll take this from the federal rules and put it in my own form. Evidence is relevant if, big word if it tends to make a fact of consequence to the litigation a little more or a little less likely than it would be if we didn't have that piece of evidence. Notice, I did not say what I see often in essays, that evidence is relevant if it tends to make something more likely than not. That's the burden of proof, to prove a fact more likely than not. piece of evidence does not have to be so strong as to make it more likely than not, but just that it makes it a little more likely or a little less likely than it would be if we didn't have that piece of evidence. It's a very slight standard. And what is the thing that it has to make a little more or a little less likely? A material fact, a fact of consequence, something that matters to this litigation. So when we look at an evidence fact pattern, it's very important to be aware. We don't jump right to the piece of evidence. We have to see who is suing whom and what they're suing for. Those introductory sentences, people often read through too quickly and don't pay enough attention. It depends what the rule of evidence that might apply. Depends on, are we in a civil case or a criminal case? What the evidence law might be that applies depends on what the nature of the lawsuit is. If it's a tort suit for the tort of battery, relevance has to be to the things that have to get proved in battery. If it's a criminal suit for the crime of larceny, what are the elements of larceny that have to be proved, right? So what is the substantive law involved so that we know what are those facts that are of consequence to the litigation? And in fact, the fact patterns will generally tell us that the plaintiff or the prosecution is trying to prove certain things and the defendant is denying some or all of those things and maybe also raises some affirmative defenses. That tells us what's in dispute. Evidence to be relevant has to help to prove or disprove one of those things. Except, why would things going to whether a witness is telling the truth, is a person who tells the truth or is not a person who tells the truth, be relevant? Why are we allowed to bring on evidence about a witness's character for truth-telling, a reputation for truth-telling, bad acts that might help to prove or disprove or help to prove that he's not someone to be relied on? Because anytime a witness is put on the stand, that witness's credibility is put into issue. So in addition to the merits of the case, the believability of anybody who is a witness in the case is relevant, and therefore anything that helps to prove or disprove the believability of a witness is in fact relevant. Very broad definition of relevance. Starting with that broad definition, we then come to policy exclusion. And federal rules basically say there's a policy test that in general says that evidence, even though it's relevant, can be excluded because it tends to undo prejudice. It tends to unduly slow down the case, be unduly duplicative, and so forth. The basic rules of excluding evidence based on just general policy. But then there are some more specific policy exclusions, and they're always tested. Those are, see the Barbary outline, examples. Evidence as to insurance, evidence as to offers to settle a case, evidence as to offers to pay medical bills, evidence about criminal negotiations directed towards settling a criminal case. All of those things, statements made in those contexts or about those matters, are certainly relevant in the sense of making something a little bit more or a little bit less likely that that is important to the case. But as a matter of public policy, the courts have decided, or the federal rules tell us, that we have just these categories. Subsequent remedial measures. If in a case the defendant is allegedly negligent on account of a sidewalk that is covered with ice, and there is evidence that the defendant went out and cleaned up the ice right after the accident, it certainly makes it a little bit more likely that the defendant is saying, gee, the situation was dangerous. However, as a matter of public policy, we exclude subsequent remedial measures because we don't want our law to discourage people from taking those remedial measures, right? That kind of thing. But of course, in addition to that rule of exclusion, there are a number of exceptions, and this is what's going to be tested on the exam most of the time. You can offer subsequent remedial measures when ownership or control is in dispute. So the defendant says, it wasn't my sidewalk, but the evidence is that the defendant cleaned the sidewalk. Then we overcome the subsequent remedial measure rule by saying the issue is here one of control. I'm not going to do a lecture that would cover all of this, but I want to say those rules of exclusion, policy exclusion, are tested generally on several questions on every exam. But the most important thing that is tested in the area of relevance are the rules of character evidence, where we're talking about not what the person did on the particular day, event in question, but about what the person may have done at some other time, or what the nature of our plaintiff or defendant is in terms of character. Now, as a matter of just common sense and common experience, if you know that a friend of yours, Joe Jones, sorry Joe, is generally a very negligent person when it comes to driving. My dear beloved and now deceased Uncle Ben had a reputation in our family. One was scared to get on the road when Ben was on the road because Ben would all of a sudden remember something and do a U-turn in the middle of major traffic without signaling, or everybody else would screech to a halt. The fact that my uncle, or Joe Jones, had a reputation as being a careless driver, or had a characteristic of generally being a careless driver, cannot be offered to show that he was careless or negligent on the particular occasion. That's the general rule. And then, of course, we have a number of exceptions. Generally can't use character or reputation to prove that a person acted, as we say, in conformity with their character or their reputation. But we're going to see all sorts of times when we can use character evidence in the sense of reputation or opinion about general behavior, or even acts that are not involved in this case as some evidence as to acts that occurred in this case. Example, we use character or reputation or opinion evidence to prove that someone who took the witness stand is not believable. We use it in terms, in other words, of impeachment. That's one big exception. We use reputation or opinion in impeachment. We'll come to that later. Another big set of exceptions, and I'm never inclined towards any mnemonic devices. This is one that sort of vaguely sticks in my mind, what's often referred to as mimic. Basically, we're talking about a criminal case in which, as a matter of fundamental fairness and due process, we say if Joe Jones, sorry again Joe, is charged with one crime, then the evidence we should put to the jury is about that crime and not about other crimes that Joe maybe is alleged to have committed at other times in the past. That would be unfair to Joe, unfair use of the evidence, even if it's somewhat more likely that a person who has committed 3 other murders did this murder. It just has to make it a little bit more likely, after all. It's highly prejudicial. So as a matter of judgment, rather than doing a balancing test here, we simply say, you cannot offer evidence of other crimes to prove that the criminal defendant did this crime unless, big unless the other crime or the other bad act helps to prove a fact of independent relevance to the case. What do I mean by independent relevance? We're not offering the other crime just to show that the defendant has a bad character, is inclined toward violence. We're offering the other acts to prove that the defendant had a motive, mimic. That the defendant had intent, mimic. That the defendant didn't make a mistake, that he knew what was going on, mimic, absence of mistake. I forget what that one is, identity. That if a crime, this crime was committed in some very unusual way, the one being charged, and there's evidence that is not part of the charge that this defendant did 3 other acts that were similarly strange, unusual, identifying circumstances, then we can offer those other crimes that are not part of the indictment in this case. Not to prove that he's a violent guy and therefore probably was violent on this occasion, but to show the identity of the person. Right? All of those rules about use of other acts when they are independently relevant get tested on a regular basis. Another big area of character evidence is character of the criminal defendant in general, where we say it just can't be offered, Prosecution is not supposed to prove that, let's move away from poor Mr. Joe Jones, to Charlie Manson, that Charlie Manson is a bad and violent guy, therefore he was probably a person who committed a murder on this occasion. Generally, the character of the criminal defendant cannot be offered by the prosecution. However, the criminal defendant is allowed to raise his own good character as evidence that he didn't commit the crime, and when the criminal defendant puts his character into issue, he has to do it in certain ways that you'll see discussed in the Barbary Outline, and the prosecution is allowed to do certain things in response only after the defendant has initiated evidence on his character as a criminal or not. Those rules are always going to be tested. So this is basically what's covered in evidence, in relevance, pardon me, the basic rule of what's relevant. Policy exclusions of evidence that's relevant, but for some reason we ought to exclude as a matter of policy either the general balancing test or the specific tests that I alluded to. And then character evidence. That's basically what we're going to see tested under the concept of relevance. Let's go to witnesses, which is our second big area. Now, I've mentioned several times impeachment of witnesses. Understand now, anybody who takes the witness stand or a hearsay declarant is someone we're asking the jury, that the party proposing the evidence is asking the jury to believe in the credibility of. Believe this witness's credibility even though you don't know anything about this witness. Now, in our own lives, we generally do know people who are not credible. We know people who we don't trust. But when we're sitting on a jury, what do we know about the witnesses? Hopefully, nothing. So is this witness a good liar, or is this witness someone who should be believed? Can we only go on the look on the person's face, whether the person's sweating and things of that sort? Does sweating indicate that someone is lying or nervous? Maybe they're nervous because they're on the witness stand, not because they're lying. Maybe whatever. So how is the jury supposed to assess this? Well, the opposing party, in fact the party even who puts on the witness, is allowed to impeach. Any party under the federal rules approach may impeach a witness, that is, put on evidence that the witness is not to be believed. And you go down the list of impeachment methods and learn them. Prior inconsistent statements to impeach. Bias or interest to impeach. Conviction of a crime by the witness. A much more complex little set of rules that we will go through. Bad acts for which the witness was never convicted. That's as distinguished from the conviction, right? We use a conviction of a crime to impeach sometimes. What if the witness allegedly did a bad thing but wasn't convicted? We're even allowed to use bad acts to impeach a witness, but only those kinds of bad acts that go to whether the witness is telling the truth or not. Only bad acts like failure or lying on income tax, filing a false police report, filing a false insurance claim, things of that sort. That kind of bad act. And the limitation is it can be offered by cross-examination only. We can ask the witness, isn't it a fact that you lied on your income tax last year? But if the witness denies it, we are not permitted to use what's called extrinsic evidence to prove that the witness is lying about that. We can ask about a bad act on cross-examination, but that's the end. We're not allowed to bring on extrinsic evidence, otherwise we wind up having a trial about the bad acts of witnesses and be led far astray, so we can't do that. Opinion or reputation about a witness. We can put on evidence by a witness who knows the reputation or has an opinion about the veracity of a witness. And we have to lay a foundation for that, and then the witness can state what he has heard. Hearsay, gossip, or his opinion of the believability of the witness. And finally, we can impeach by sensory defects. Sir, isn't the fact that you're night blind and can't see at night? If you can't see at night, how could you possibly have seen what you purported to see? We can go to the sensory defects of the witness. These are methods of impeachment. The other big area that's tested about witnesses is privileges. The federal rules did not adopt a detailed set of rules about privileges, but left it generally to the evolution of a federal common law with one caveat. The federal rules say that in a diversity case, a case that's in federal court only on account of diversity of citizenship, remember back to the Erie case, which you probably studied in your course in civil procedure, when a federal court is hearing a case as jurisdiction only because the plaintiff and defendant are citizens of different states, and not because federal law creates the cause of action, then we should apply state law, not federal law, to the dispute. But what federal law? Roughly, very roughly speaking, federal law of substance, not federal law of procedure. So now, what is substantive and what is procedural? Well, at least in terms of the federal rules of evidence, they decided ahead of time. Privileges are substantive so that a federal court hearing a case on account of diversity will use state law of privilege. There are two other areas in which a federal court will use state law in a diversity case. Privileges, one. Burdens of proof is a second, and presumptions related to that. And third, competence of witness. Who is a competent witness? But privileges is the big one that's often tested. So, federal court based on diversity, state law of privilege, federal question case in federal court, federal law of privilege. Okay? And then, what is the privilege? What things are privileged? What causes people to lose the privilege? All the details, every detail in the Barbary Long Outline is something worth your reading and thinking about on the 4 or 5 occasions when I will assign the outline to you. Let's leave that, privileges, for you to read in more detail. Now I'm going to mention briefly before we move on to hearsay that Barbary has a nice chapter on documents, raising a number of related issues. So as soon as we see we have a document involved, we have to ask, is that document relevant? Because everything has to be relevant. Is that document authentic? Is it what it purports to be? Is there a best evidence problem? Is this one of those instances in which we need the original document or an explanation for its absence, or are we allowed to have a witness telling us what the content of the document was? Parole evidence rule, basically see your course in contracts, but think about it a little bit in terms of the law of evidence. And then the big thing with documents, every time you see a document, think about whether there's a hearsay problem. We'll come to hearsay in just a minute, but you've got to think about hearsay with any document. Let's move to hearsay. Now the definition of hearsay, easy enough to master. And I see people stating it over and over again in essays in evidence, and then going on to show that they really didn't understand it. I think one of the reasons for this is that evidence professors, being experts, of course, in evidence, find the recognition of whether something is or is not hearsay so easy they don't spend enough time on it. But for the rest of us who are not specialists in evidence, it can be tough. Evidence is hearsay if it involves a statement not under oath in this trial or proceeding and is offered for the truth of the matter. Now let's break that up a little bit. We need a statement. Hearsay involves a statement. The statement has to be not under oath in this trial or proceeding. Old rough rule of thumb said hearsay evidence was statements out of court. But in fact, a statement can be made in court and still be hearsay if it was made not in this trial or proceeding, but in another trial or proceeding, or in an earlier deposition in this case, or in a preliminary hearing in this case. It's hearsay if it's a statement not under oath in this trial or proceeding. So in other words, this jury was not there when it was made, and offered for the truth of the matter asserted. Simple sounding, but the hardest part. How do we know whether a statement is offered for the truth of what that statement asserts? Well, I'm going to suggest to you, you can never decide whether something is hearsay without thinking what it is relevant to proving. And so if you're writing an essay in evidence, and you see, as you very often will, something that just jumps off the page at you, and you say, that's an issue of dying declaration exception to the hearsay rule. That's an issue of former testimony exception or whatever. And you want to jump right on the exception. The issue here is whether we don't need a hearsay exception unless we first ascertain that the statement actually is hearsay. And we can only ascertain that the statement is hearsay if we have ascertained that it is offered for the truth of the matter asserted. What are the chances the bar examiners are going to tell you that this statement is offered for the truth of the matter asserted? Or even tell you what the statement is offered for? Slim. Very seldom. So we have to figure out what the statement is offered for so that we can figure out whether it is offered for the truth of the matter asserted. We have to think, what could this piece of evidence be offered for in this case? What is it relevant to that's in dispute in this case? Once we think, what is it relevant to proving, then we can ask, must the jury find that the statement is true in order for it to serve the purpose of proving what we're offering it to prove? Are we offering the statement, oh my God, look at that red light, to show that the light was red, or to show that someone heard that the light was red and therefore was on notice? Look at all the instances where Barbary tells you that something is offered for something other than truth, to show that someone heard it, to show that there was notice in the person who heard it. We'll come later to state of mind as an exception to the hearsay rule, but I'll give you a nice example of state of mind that is not hearsay at all. Excuse me, but I am the Lord thy God. I want your money. Now, while this tape is running, if someone in the back of the room would please take a hat and pass it around, and all of you should put all of your money in that hat, because I, Richard Litvin, am the Lord thy God, and I need thy money right now, because I needed to build an airplane that is going to carry me home to my true home in heaven, which is on Mars. That statement, which you have now heard, is being offered into evidence. Any chance that that's being offered to show that I really was the Lord thy God? Most likely not. Most likely it's being offered to show that the person who made the statement was crazy, was probably incompetent to make a will at the time he made that statement, or whatever. Therefore, the statement is offered to show the state of mind of the speaker, and not to show that the state of mind was true, or that what the speaker said was true. We're not trying to persuade the jury Litvin was God, but rather that Litvin was crazy. If I say, I offer to sell you my car, we could be offering it to show the truth that I really intended to sell my car, but more likely we're offering it for the legal consequence that it is an offer, even if I didn't mean it, that you can accept. And therefore it's a legally operative act, and therefore not offered for the truth at all. Be very careful about going through all of the reasons that something might be offered into evidence that are not for its truth, that make it not hearsay in the first place. Prior inconsistent statements offered to impeach a witness. Not offered to show that what the witness earlier said was true, but just to show he made inconsistent statements and therefore should not be believed. If offered to impeach a witness, a prior inconsistent statement is not hearsay. This is all going to be very important to us as we go on. So if we now find that the statement is relevant, and we now find that the statement is offered to persuade the jury that what the declarant said is true, we now have hearsay. Life gets more complicated because the federal rules say even those things that fit the definition of hearsay, some of them are going to be non-hearsay. Now notice, I'm not yet talking about the groups of exceptions to the hearsay rule. In terms of the structure of the federal rules of evidence, stuff can be non-hearsay if the declarant is available for cross-examination right now. That's critical. The out-of-court declarant, it doesn't have to be out of court. He could be sitting right here in this case. Could be, in fact, on the witness stand right now. We can even be asking the declarant who happens to be the witness in this case, we could be saying, Mr. Jones, what did you tell the police? Objection, Your Honor, hearsay. We're asking Mr. Jones not what happened in the real world, but what he said, and if it's being offered to show that what he said was true, then he is not only a witness, he's also the declarant. Does that mean it is hearsay? It could still be if it's offered for truth. But if our out of court, or forgive me for that, if our declarant is available right now for cross-examination, it is non-hearsay if it fits one of three categories. This is pretty tricky, right? Declarant available and prior inconsistent statement under oath. Contrast that with former testimony. Different but similar. Prior inconsistent statement under oath, 1. 2, prior consistent statement, but only when offered to rebut a claim of recent fabrication. Not all prior consistent statements come in as non-hearsay. Only prior consistent statements offered after the witness has been impeached. We impeach him, and then we can bring on a prior consistent statement to rehabilitate, and it comes in for all purposes, even its truth. 3, prior IDs. Sir, did you identify someone as the murderer at the police station? That's a prior identification made at the police station, but the declarant is available right now for cross-examination, is sitting on the witness stand. So, 3 instances, if the declarant's available, it might be non-hearsay. But if it doesn't fit one of those exact classifications, it's still hearsay. Second big group of non-hearsay statements that fit the definition of hearsay: party admissions. Under the federal rules, party admissions are not a hearsay exception. They are simply non-hearsay, which makes a difference when it comes to what's the right answer on an MPE question. If something fits the requirements of a party admission, it is non-hearsay. Right? Now, what is a party admission? It's any statement made by a party. Any statement. Doesn't have to be a, quote, confession. Doesn't have to be that the party is aware of being guilty of anything or having done something wrong. Any statement by a party offered against that party, it's got to be offered against the party, not by the party, for the party, is party admission. Now, what's included is not just statements of the party, but statements of agents of the party and so forth. So you need to really study that carefully. And the big problem then is to recognize party admissions. Understanding them is one thing. Recognizing them in the fact pattern, remembering them when you see a statement by a party coming up in a fact pattern, is something that still eludes many people who are perfectly aware of the rule. Now, we have gone through what is hearsay, what is non-hearsay. Only then do we go to the exceptions. That's the order in which you want to consider these things. If something is non-hearsay, don't pick a hearsay exception on the multi-state. It will not be the best answer. If it's if it's party admission, but it might also fit the state of mind exception, go for party admission. If it's a party admission, but it might also fit some other exception, just don't pick the exception. Now we have 2 groups of exceptions. I'm not going to go into the details. They're all laid out beautifully in the Barbary outline. You'll hear them all laid out beautifully in the Barbary lecture. This is not my job. But be aware there are 2 groups. One group requires that the declarant be unavailable. It's the opposite of the non-hearsay stuff. The declarant, whoever he or she is, must be not available. Now you might think not available means dead. No, it doesn't have to be dead. You might think not available means not in the court. But in fact, someone can be sitting right on the witness stand and be not available because they're taking the Fifth Amendment. They're claiming spousal privilege. They have no memory of what happened. They're unavailable. They've become unavailable in some way that the federal rules recognize. Read what makes a witness unavailable, or now a declarant unavailable. If the declarant's unavailable, then certain kinds of statements by that declarant fall under the exception, the primary ones being a declaration against interest, a dying declaration, former testimony. And you want to know the requirements for each of these because every one of them is tested all the time. Every bar examination, every MBE, you can see them. Then there is the big long list of exceptions where we say, Whether the declarant's available or not just doesn't matter. If it's a statement not under oath in this trial or proceeding and offered for the truth of the matter asserted, it still comes in under a hearsay exception if it's a present sense impression of the declarant. Be clear on that. The declarant has to be saying what the declarant was perceiving at essentially the instant of perception. Look at that car running the red light. I'm not excited. Just, oh, that car's running the red light. Look at the woman in the blue dress. I just heard the sound of crunching metal. I just heard a dog bark. Immediate statements of what one is of what the declarant was perceiving are present sense impressions. Now, the common mistake is to imagine every time a witness says, you know, I was at the scene and this is what I saw, that this is a present sense impression to the hearsay rule. But of course that's wrong, because when a witness says on the witness stand, this is what I perceived at, there's no hearsay. The witness is not referring to an out of court or a prior statement of his, but rather just to what he perceived. We don't need the present sense impression exception to the hearsay rule unless the statement is hearsay to begin with. So, present sense impression exception. Big one appears every multiple choice test several times. Right answer sometimes, wrong answer others. Present state of mind. But now I'm not talking state of mind as we were talking earlier, where we're using it to show the state of mind of the declarant as being crazy, but rather state of mind to show the truth of something. The typical example is, I intend to go to New York tomorrow, and that statement that I made is now offered in a case in which it's of some significance whether I was in New York on that next day or whether I was in California or somewhere else that next day, because if I was in New York then I wouldn't have been at the scene of the crime. State of mind of the declarant about what the declarant himself intends to do in the future. Now read that carefully, because very often people start seeing state of mind exception where it doesn't belong. If I say, I believe that my wife is going to kill me, that might very well be my state of mind, my belief about what someone else is going to do in the future. That's not what we mean by state of mind exception. Or, I believe that Jones caused the accident. My belief about past states of affairs, not within the state of mind exception. It's my state of mind about something that's relevant to the case, offered for the truth that something did happen, that I intended to do what I said as some evidence that I actually did it. That's certainly at least the most typical example. So you've got to read the details to see what's within the state of mind exception and what is not. Okay, that's big. Sense impression, state of mind, bodily experience. Two rules. One is present bodily experience, said to anybody, ouch, my back hurts so much, ooh, ooh. Anybody who hears me can testify, I heard Litvin say that his back hurt on whatever the day was. If it's relevant to this case, because the question was I injured in the car accident or whatever, doesn't have to be medical personnel. But there's a related or similar exception for statements about bodily condition made for purposes of diagnosis or treatment. And those are not present bodily experience, but what happened to me said to a doctor or other medical personnel for diagnosis or treatment. That only comes in if it's medical personnel and for diagnosis or treatment. But it doesn't have to be present. Big, big, big business record exception. What is within and what is not within the business record exception has appeared on every MBE that's been released, generally in several questions. Sometimes something falls within the business record, sometimes it doesn't. Public records, which may look sometimes very much like business records, but read the details of the public records exception. Now, in addition to the ones that I've just mentioned, there are a host of others, and you don't need me to tell you. You can read them in the outline and read them again and read them again. I've mentioned those that are most heavily tested. The Barbary lecture will go into much more detail. The outline goes into even more detail. I want you to read every bit of it. But the ones I've mentioned are tested over and over and over and over again. So we have an approach to hearsay. Is it relevant? So we know can figure out whether it's offered for truth. Is it within the definition of hearsay? Statement not under oath in this trial or proceeding, offered for the truth of the matter asserted. If so, does it fit one of the non-hearsay categories, either where the declarant's available, 3 subcategories, or where the declarant happens to be a party and the statement's offered against him, party admissions? Or does the statement fall within one of those 2 big groups of hearsay exceptions, those in which the declarant must be unavailable, or those in which, or for which, the declarant's unavailability doesn't matter? You can easily see how 10, 11, 12 questions on every exam could come out of the complexities of the rule against hearsay and its related doctrines. And that is going to be as heavily tested or more heavily tested than just about anything on the whole exam. The law of negligence and torts is tested somewhat more, but hearsay is very, very, very big. Now, I just skipped something that I think is very important for you to focus on. Happens to be covered in the Barbary Outline in 1 sentence. It's called multiple hearsay. It has been on every released multi-state, usually involved in several questions. And it's far from obvious. And on evidence essay questions in most jurisdictions that test evidence on essays, it's tested a lot. Multiple hearsay. Hearsay within hearsay, totem pole hearsay, all sorts of different labels for it. When one statement is inside of another statement, which is maybe inside of another statement, each one of those statements has to be tested in terms of, is it hearsay, and if so, can we overcome the hearsay objection? Example, I am the witness on the witness stand, and I am asked, what did Jones tell you? And I want to answer, Jones told me that Smith told him. Well, now I have 2 out-of-court declarants, 2 not in this trial or proceeding, Jones and Smith. Smith said something to Jones, Jones said something to me. We have 2 statements that were not in front of this jury. Each of those we have to consider, was it offered for the truth of the matter asserted, and if so, is there an exception for it? On the statement of Jones to Smith and on the statement of Smith to me. Each of them has to be thought of in terms of whether it is subject to a hearsay objection and whether it can overcome that. So it can come up just in terms of a witness being asked about what someone told him that someone else told them. More commonly, it comes up with documents. Here's a document. It is arguably within the business record exception, but it also contains statements by people who are not within the business record exception. Example, generally medical records come within business record exception. Any record ordinarily kept in the course of the business for business purposes, like the chart of a patient at a hospital. And that includes things that are said by people employed by the hospital about matters within the scope of that employment. So the nurse writes in the hospital record, the doctor writes in the hospital record, the nurse says in the hospital record, doctor said. All of that is within the business record exception generally. But what if in the hospital record, the doctor writes, patient told me that Jones hit him over the head. Now we need some way to get the patient's statement in, not just the business record in, because the patient statement is not within the business record exception. The patient statement may come in within that other exception of statement to medical personnel for diagnosis or treatment, or maybe not. Or maybe it's not a statement by the patient at all, but by a relative of the patient who says, gee, doc, I got to tell you, mom was drunk when she fell down. Statement of someone who's not a party to the case, but a relative to the doctor. That within the medical record requirements? No. The son does not work for the hospital, son does not work for the doctor. It's not a party admission. Is there any way to get it in? We have to consider hearsay objection to the son's statement as well as to the medical record itself. Police investigative report. Policeman is out investigating the cause of an accident. Things that the police officer observes himself or herself and puts in the record are the equivalent of the business record, the investigative record, and they come within the public record investigative record exception. But part of the police officer's investigation was questioning of people at the scene, and the police officer writes in the report, a witness told me. Well, the witness is not within the public record exception. We need another exception, or assuming the witness's statement is a statement not under oath in this trial or proceeding, and offer